And then we're going to move over to Tulani's question. The second question is from Tulani, and this is specifically an eviction question, a very nice and short one. It says, yeah, hey, my grandfather was wrongfully evicted from his property, stating that someone has bought the property. Funny enough, the municipality bills come with my grandfather's name as a rightful owner of the property. Any advice or please help?
Sure. Look, I think the answer here is going to be short and sweet. There's two things that need to be mentioned. So if you sell the property, if the property gets sold in execution, whatever reason there might be for you to have past transfer to somebody else, that does not automatically mean that the municipality has changed the account holder on their side, right? Very often, it's the responsibility of a purchaser to approach the municipality once they've bought the property to make sure the municipality changes the account details, right? So that's just something to bear in mind. The fact that her father gets the municipal bills every month doesn't mean anything but the municipality hasn't been updated with the correct details, right? Now, the more important part of the answer is, if there's any doubt, consult the deeds office. It's simple. The deeds office would carry all the records of every property transfer and property sale that would have taken place. That does not necessarily mean that it is legit, that the sale took place properly, but at least you'd get view or a sight of the record, in terms of which it was transferred. So hypothetically, let's say I own a property and tomorrow somebody pitches up and they say, I'm owner, get out, right? Now, I would want to go to the deeds office and see, wait, what happened? How is this guy owner of the property? Number one, is his name there? If his name's not there, then he kicked me out unlawfully because he's not owner of the property. So then I should be entitled, unless he had an eviction order, I should be entitled to get my property back. If he did get an eviction order, look at the eviction order and what the papers say. If the title deed does show him as owner, then the title deed would also show how he became owner. So maybe somebody fraudulently sold the property, and that's been happening now, where people sign documents, they fake the owner's name, and they take cash as a purchase price and they run away with it. So there's been stuff like that have gone through deeds offices. It's happening less now because the Law Society then came on the basically and climbed into the conveyances saying, but how are you getting these guys to sign documents without verifying who they are? So it's a bit complicated, but it can happen where a property is sold fraudulently, but you'd be able to trace this and very easily set it aside. And the last thing, and this happens very often, and this is normally where this question arises from, is if the property was sold in execution, which is typically the case in instances where a person doesn't pay their bank, so their mortgage doesn't get paid off. If it was sold in execution, it happens, the seller or the owner of the property is notified, but they never actually sign any documents allowing the transfer to take place because the sheriff does all of that, meaning that a person loses ownership without, I wouldn't say without realizing that they've lost ownership, because obviously they'd be notified that there's a foreclosure, but they lose ownership without, kind of pressing the button for transfer to be passed. And unfortunately, that does happen quite often. In that instance, your recourse probably lies against the bank that foreclosed and figuring out why they foreclosed, especially if you have been paying your bond. But that would pretty much cover all scenarios